Okay, let's unpack this. Imagine you're running a big construction project, juggling contracts, payments, deadlines. Everything seems to be humming along. You send an invoice for work done, application for payment number 8, let's say, and then, well, crickets.
Right. The payment doesn't arrive.
Exactly. And worse, the other side doesn't just not pay. They try to change the subject entirely, maybe start a whole separate dispute. What happens then?
It's a tricky situation.
Well, today we're diving into exactly that kind of scenario. We're looking at a high court judgment from July 18, 2025.
That's right.
It involves VMA Services Limited and Project One London Limited. We call them VMA and POL. Yeah.
That's good. Much easier.
And it's a real deep dive into this fascinating, sometimes pretty aggressive world of smash and grab adjudications in construction.
Yeah, what's truly compelling about this one ruling, VMA v. POL, is how it really sharpens our understanding of these key legal principles, the ones designed basically to keep cash flowing in the industry.
So important.
Absolutely. So our mission today really is to explore not just what happened between them, but why the court made the decision it did, and crucially what that means for anyone navigating these complex contracts.
Okay.
Because at its heart, the big question for the court was, could an adjudicator actually order payment to VMA, even though POL, the paying party, was the one who kicked off the adjudication?
Which just sounds backwards, doesn't it?
It really does. It seems to challenge a widely understood rule, and that's where it gets really interesting.
Okay, so let's set the scene a bit more. VMA and POL, they had a contract, right, signed back in late 2023.
Yep, October 16th, 2023, for mechanical works on a London property.
Oh.
Chain walk, I think.
And it was a pretty standard setup, using the JCT design and build subcontract conditions from 2016. So fast forward to June 2024. VMA puts in their application for payment number 8 for work done up to the end of June.
A fairly straightforward interim application on the face of it?
It should have been, but you mentioned PL's response or lack of it?
Yes, and here's the absolute critical point. POL did. Well, nothing, in terms of notices anyway.
No payment notice.
None, which is their chance to say, okay, we agree, this much is due.
And crucially, no pay less notice either.
Not a sausage. No pay less notice saying, hold on, we dispute this amount, and here's why, and here's what we are paying. Nothing. Timelessly or, well, at all.
All right.
And that complete failure, that silence on the notice front, is the bedrock of this whole dispute. Because without those notices, that $106,434.88 automatically becomes what's called the notified sum.
The sum that, in theory, just has to be paid.
Pretty much. But TOL, despite not paying, they decided to go on the offensive. December 16th, 2024 rolls around.
And he started an adjudication. That seems bold, given they hadn't paid. What was the strategy there?
Well, it wasn't to get money from VMA, obviously. They launched what's called a true value adjudication, or TVA.
A TVA. Okay. What does that entail?
Essentially, POL was arguing that VMA's original application, that $274K gross figure, was just way too high.
Ah, I see.
They were saying the actual value of the work done was much lower. They suggested around 89,000 pounds, I think. So they were trying to get the adjudicator to decide the true value, kind of ignoring the notified sum issue they'd created by not sending notices.
Trying to change the question.
Exactly. But VMA, quite understandably, weren't having any of it. They filed their response in early January 2025.
And this is where they brought up the unpaid notified sum.
Absolutely. They raised PL's failure to pay that $106K as both a defense to PL's true value claim and, importantly, as a counterclaim. They basically said, never mind the true value for now, you owe us this notified sum.
So setting up a direct clash within the adjudication. PL wants to talk value, VMA wants to talk payment owed now.
Precisely. And the adjudicator had to navigate this. They approached it quite methodically, actually.
How so?
They broke it down. First, was VMA's payment application valid in the first place? Answer, yes.
Okay.
Second, did POL issue a valid payment notice or pay less notice? Answer, no. We already know that.
Right. Still no.
Third, what sum was therefore due as the notified sum?
Straightforward enough based on the lack of notices.
It was. And then the adjudicator made a really crucial finding. They said because VMA's argument about the notified sum has succeeded as a defense, they were therefore not required to go on and determine the true value of the works.
Ah, so PLL's original reason for starting the adjudication got sidelined.
Effectively, yes.
Yeah.
Because the immediate payment obligation took precedence in that specific procedural context.
So the adjudicator's final decision was...
Clear cut. POL must pay VMA the notified sum of $106,434.88, plus interest, of course. About 5,600 pounds in interest had accrued by then.
Wow. So VMA won the point, even though they were the responding party in PLO's adjudication.
They did. A clear decision on the notified sum.
So, okay, let's take a step back. What does this adjudicator's decision and the subsequent court case upholding it mean for the bigger picture in construction law?
Well, it brings us right back to the fundamentals. The Housing Grants, Construction and Regeneration Act, 1996, the HGCRA, and the Scheme for Construction Contracts that sits alongside it.
The bedrock legislation, really.
Absolutely. And the core intention behind all of this, especially after the big changes back in 2011, it's fundamentally about one thing: cash flow.
Keeping the money moving.
Keeping the money moving.
Right.
Preventing projects from grinding to a halt just because someone decides to withhold payment without following the rules.
Which leads us neatly into these smash-and-grab adjudications, doesn't it?
It does. It sounds aggressive, and sometimes it is, but think of it as maybe a legal fast track for payment when the rules haven't been followed.
Okay.
Since those 2011 changes, the case law has become really clear. If an employer or a main contractor, like POL here, fails to issue a valid payment notice or a valid pay less notice on time,
they're in trouble.
They essentially lose the right to argue about the amount at that point. They must pay the sum applied for by the contractor, the notified sum. It creates an immediate, almost automatic obligation to pay.
It's designed to stop people just delaying without a proper reason set out in a notice.
Exactly. No notice, you pay now, argue later if you must.
And this connects to something called the principle of subjugation. I remember seeing that mentioned.
Yes, spot on. That principle was really clearly laid out in a case called Bexheat a couple of years ago, 2022.
Okay, Bexheat. What did that establish?
It clarified this sequence. 1, employer fails on notices. 2, immediate obligation to pay the notified sum arises. 3, the employer does still have a right to argue about the true value. Later, maybe they think they overpaid.
Right.
But, and this is the subjugation bit, that right to argue the true value is subjugated to the immediate payment obligation. It comes second. You can't start a true value adjudication until you've paid the notified sum that's immediately due.
Pay first, then argue.
That's the essence of it. The immediate payment obligation is paramount.
Okay, that makes sense for enforcing payment. But here's the bit that still feels odd in the VMA case. Normally, in an adjudication, if you're the one responding, the one being claimed against, you can defend yourself, right? You can say the claim is too high, maybe raise a counterclaim to reduce the amount, a set-off perhaps.
Yes, absolutely. That's standard.
But there's a general rule, isn't there? I think it came from the Supreme Court in the Bresco case in 2020.
Yes, Bresco. A very important case on adjudication and insolvency, but it had broader points, too.
It basically said that the responding party generally can't use the adjudication initiated by someone else to get their own payment order, right? They can defend, reduce the claim maybe to zero, but not get money back from the claimant through that process.
That's the general principle, yes.
Right.
You can use your counterclaims defensively as a shield, but not usually as a sword to win your own payout in that specific adjudication. You typically have to start your own separate claim for that.
So for VMA, who were the responding party here, to ask the adjudicator, okay, not only do we defend POL's claim, but you need to order POL to pay us this $106K. That's where it bumps up against that Bresco principle.
Exactly. That's the nub of the high court challenge. Did the adjudicator even have the power, the jurisdiction, to order POL to pay VMA, given VMA was the respondent?
So this was the core question the high court had to grapple with in VMA v. POL.
Precisely. Did the adjudicator overstep their bounds by ordering payment to the responding party?
And what arguments did VMA make to say, yes, the adjudicator could do that?
Well, they tried a couple of things. First, they pointed to a paragraph in the Scheme for Construction Contracts, paragraph 20B, I think.
Yeah.
It says something like, the adjudicator can decide that any of the parties is liable to make a payment. VMA argued this meant the adjudicator could order POL to pay them.
Makes sense on the surface.
The judge, Adrian Williamson Casey, wasn't entirely convinced by that line alone. He basically said, yes, it allows the adjudicator to decide liability, who owes what, but it doesn't automatically translate into the power to order payment to a responding party in that specific adjudication. It's a subtle distinction. Deciding liability versus ordering the cash transfer.
Okay, so that argument didn't fully land. What else did VMA have?
They then relied heavily on another case, a precedent from 2020 called WRW Construction Limited.
WRW. What happened there?
It was quite similar, actually. In WRW, an adjudicator had ordered a sum to be paid to the responding party, WRW. And when it went to court for enforcement, the court upheld it. They enforced the decision.
Ah, so there was a precedent for this kind of order being enforced.
Exactly. The judge in WRW made a strong point. They said there was no real barrier to the court enforcing what was effectively a temporarily binding valuation, the adjudicator's decision, by ordering the payment. And importantly, the WRW judge said it would be contrary to principle, basically illogical and inefficient, to make the winning party, WRW in that case, start a whole new adjudication just to get a formal payment order for a sum that had already been decided as due in the first one.
Just creating extra steps and costs for no real reason.
Precisely. Why go around the houses when the adjudicator has already determined the immediate entitlement?
So how did Judge Williamson Casey in the VMA v. POL case view this WRW reasoning?
He found it persuasive, very persuasive, in fact. He explicitly decided to follow the WRW approach.
So he sided with VMA on this point.
He did. He acknowledged the general Bresco principle, no monetary recovery for the respondent usually, but he carved out an exception. He said, essentially, where there is a determination that a particular sum is immediately due to a respondent, like VMA's notified sum here, different considerations apply.
Because the payment obligation was so clear and immediate due to the lack of notices.
Exactly. The judge felt that the specific nature of the notified sum, arising directly from POL's failure to serve notices, put it in a special category where the WRW logic should prevail over the general Bresco limitation.
And he agreed with the efficiency argument, too, that forcing VMA to start again would be pointless.
Absolutely. He explicitly said it would be an arid exercise, completely dry, pointless, futile, to make VMA go through the hoops of another adjudication just to enforce a sum already clearly decided as immediately payable.
So it aligns with the whole point of the act. Quick resolution, keep cash flowing.
Very much so. It's about practical reality and the policy behind the legislation, not just rigid procedure for procedure's sake, especially when that immediate payment right is so central.
What about POL's counter-arguments in court? Did they try to argue against this WRW logic?
They did. Their counsel tried to argue that, well, maybe something might turn up in a future true value adjudication that could provide POL with a defense against paying the notified sum.
Clutching at straws a bit.
The judge certainly thought so. He wasn't having any of it. He rejected that argument quite firmly. He said accepting that would turn on its head the whole process of adjudication and undermine the pay now, argue later principle for notified sums.
So the message was, the notified sum is due now. If you want to argue about the overall value later, fine. Start your TVA after you've paid.
Precisely. Once that notified sum is determined as due because of the notice failure, it must be paid. Any subsequent squabble over the true value is a separate matter for potentially another adjudication or court proceedings, but it doesn't negate the immediate obligation.
So the final high court ruling on this crucial point.
The High Court concluded unequivocally that the adjudicator did have the jurisdiction, the power, to order POL to pay the awarded sums, including the notified sum, directly to VMA, even though VMA was the responding party.
Upholding the adjudicator's decision.
Correct. A significant confirmation of the WRW principle in the context of notified sums.
Now, I gather POL didn't just challenge on jurisdiction. Did they try other arguments, too? Like procedural unfairness or something?
They did, as often happens when a party loses an adjudication. They tried to argue the adjudicator had exceeded their jurisdiction in other ways, or that there'd been a breach of natural justice, basically, procedural unfairness.
Standard challenges, almost.
Pretty standard, yes. And the judge gave them short shrift, really, if we zoom out for a second. He dismissed these challenges quite robustly. He called it a classic case of a losing party seeking to comb through the adjudicator's reasons, trying to find any possible flaw to re-argue the case.
Something the courts generally discourage.
Strongly discourage. The judge was clear. The adjudicator had identified the key issue. The notified sum acted fairly, given both sides plenty of opportunity to make their case on that specific point, and reached a clear decision within their power. No breach of natural justice, no excess of jurisdiction on those other grounds.
So all those other challenges failed. The core decision stood.
It stood firm.
Okay. So wrapping this up, what does this deep dive really tell us? What should you, listening, take away from the VMA v. POL saga?
Well, I think it powerfully shows how the legal system, even with all its, complexities and detailed rules, ultimately strives to enforce fairness and, crucially in construction, maintain that vital cash flow.
That pay now, argue later ethos for notified sums is strong.
It's very strong. This case reinforces that the smash and grab principle for notified sums is alive and well. If you're the paying party, you must get your notices right. Otherwise, you face an immediate payment obligation.
And the nuance we explore today about the adjudicator's power to order payment to the respondent in these specific notified sum cases.
Yeah.
That's a key clarification, isn't it?
It really is. The High Court confirmed that the immediate obligation to pay a properly notified sum is paramount. And, crucially, that adjudicators can, in these circumstances, make that direct payment order to the respondent.
Why? To uphold the spirit of the act.
Exactly. To ensure efficient dispute resolution, to prevent those pointless, arid further proceedings, and ultimately to keep the cash flowing as intended. It avoids unnecessary delays and costs.
So, a pragmatic decision rooted in the policy of the legislation.